it is the losing party, that pays the entire fee of the successful party. In India, the law hinges on reasonableness of costs. That to my mind is a sore point. I'm a big advocate of the losing party bearing the entire cost of the winning party. But I think in our jurisdiction, law still needs to evolve because it hinges on reasonability. Just narrating in 2 minutes, something that I have faced in courts. In one of my matters where I won the arbitration, I was, of course, asked by the tribunal to submit, my entire statement of cost, which I submitted. I was led by a senior lawyer in the Section 9 petition. I had included that cost also, and of course the entire cost of arbitration. Right now, the claim was small, and my cost that I had provided touched about 50 to 55% of the claim amount. Right, in the entire Section 34, which the court entertained, the 34 court dedicated a lot of time on reasonability of the cost, and I was trying to impress upon the court that, look here, I'm the winning party. I am providing you with the statement of the entire cost that the claimant has incurred during the conduct of the arbitration. But there was a lot of pushback, from the court, and there came a time where my client finally said, Rajat, let's go ahead and settle the matter. Let me just forget about about 50% of the legal fee that I had incurred. I'm happy taking 50% of the legal fee, and let's wrap it up, right? Because there was needless time which was being spent on the point of determination of what is reasonable and what is not, right? Coming to 31A, which is the regime for costs. Here, of course, the tribunal has wide jurisdiction in determining whether costs are payable by one party to another. When are those costs to be paid, and what are the amount of those costs which are required to be paid by the tribunal? Thank you for putting it up. Now, of course, as I said, look at the explanation and you'll see the point that I was making. For the purpose of this subsection, cost means reasonable costs relating to fees and expenses of the arbitrator, courts, witnesses, legal fees and expenses, administration fee of the institution supervising the arbitration, any other expenses incurred in connection with the arbitral or court proceedings, and the arbitral award. So in a sense, the tribunal has to consider, costs in a wholesome, must cover the entirety of the costs which have been incurred by the parties in the arbitration. To my mind, the losing party must bear all of the costs, and that's what has also been provided in Section 2A, which says that the general rule is that the unsuccessful party shall bear the cost. However, what you will see in 2A, the word entire is missing, and that's where the courts get stuck. Because then the tribunal say that, look here, we have got discretion to grant only a quantum of the legal cost that has been incurred. Now, suppose 100 rupees has been incurred in legal proceedings, the tribunal may grant 20%, 30% of the entire legal costs, which is what they do grant as a matter of practice is administration expenses are granted in full. Mostly now in the last 5 years or so, the entire cost of the arbitral tribunal are also granted, and some part of legal fee which has been incurred by the claimant in representation of his case before the courts and before arbitral tribunal are granted. Again, and this is the point, Palak, that I was making in response to your question. I'm referring to subsection 3 of 31A. Now, when the courts determine costs, what they also determine, what they consider is, number one, the conduct of the parties. Who has succeeded and whether a party has succeeded partly. Somebody has made a frivolous case, whether there has been a bona fide, request for settlement or an offer for settlement, which has been rejected by the other side. Now, all this is conduct, which the arbitral tribunal has been mandated under law to consider. The next part, 31.4, the court or arbitral tribunal may make an order under this section, including the order that a party shall pay. Now, here is the discretion, that I was talking about, because the word used is may, and the tribunals, depending on a host of factors which have been provided for in the statute itself,